Hey, so in this video, we're going to talk about the Louisiana Small Succession Affidavit and what you need to know in case you feel like it may be applicable to your situation. Okay, so let me give you the background. Most people perceive what in Louisiana we call a succession, what other states call a probate. Most people perceive that as being difficult, probably because in most cases it is. It's expensive, it's time consuming, at least that's what people tell me they feel about it. And it kind of clogs up our judicial system. Every time somebody dies with something in their name, they got to go through the whole court system because it was determined a long time ago that it would be our courts who would determine, who would oversee the settlement of people's estates when they died with something in their name. So years ago, and I think in an effort to maybe simplify it for the smaller estates, the legislature created this small succession affidavit procedure. And if you meet the requirements of the small succession affidavit procedure, there's still paperwork that needs to be done, but you skip the process of having to get judges involved in court orders. You get paperwork prepared, signed by the heirs, submitted to financial institutions, or filed in conveyance records of the parish where somebody may have owned some real estate, and that takes care of it, and things get transferred. So the first thing I want to go over is when the small succession affidavit procedure applies. I'm going to go over one, the more popular scenario when somebody died domiciled or living in Louisiana. And then I'm going to go over what happens when you have somebody who dies living in another state, but they owned a piece of property here in Louisiana. So now we'll start with the person died, they lived in Louisiana. Their estate qualifies for the small succession affidavit if they died what's called intestate. That means they didn't have a will, and either they had less than $125,000 of gross assets, or they died more than 20 years ago, or at least more than 20 years from when this affidavit is filed or recorded. So it really ought to be called maybe the small or old succession affidavit, but quite frankly, it's mainly used these days just for the small successions of someone who died recently and the family can't get to the money or the family can't sell the property. All right, so now if we go to outside of Louisiana, and I say this because I'm handling one of these, today. For someone who died out of state and they owned a piece of property in Louisiana. So the small succession affidavit procedure applies for somebody who lived out of state and they died, but they owned a piece of property here in Louisiana. Now that one, they can have a will, but we need to get a certified copy of the will that was filed in that other state, and we need to get the probate order that the judge signed in that state. So the rationale there is, if a person lived outside of Louisiana, of course we need to see the will to see who the heirs are, so we can get the names of the heirs into the affidavit correctly. And then, but if they lived here in Louisiana and they had a will, well, we need to get a judge to declare that the will is valid before we can do anything. And if we're going to do that piece, then we're doing a succession anyway. So there's some rationale there for why in the heck you can only do this in Louisiana when a person dies without a will, but you can do it if someone out of state either didn't have a will or had a will. Seems to not make any sense at first glance, but actually I think does make some sense. Okay, so the next thing I want to go over is, this is a message really for several people, but I'm gonna narrow it down to the bankers. So what happens, and this is where people get tripped up, is dad dies or somebody dies and they had an account at the bank, and let's say there was $50,000 in the bank account. Kids go to the bank to try to get to the money. Banker says, I'm sorry, we had to freeze the account, no access to it. And then the banker immediately says, and this is where things start to go wrong, but the bank account's only $50,000. That's less than $125,000. All y'all need to do is a small succession affidavit and we'll give you all the money. That's where the mistakes are made. So then what happens is the family comes to my office and they say, our dad died. He had this account at the bank. It's worth $50,000. And the banker said, we just needed to do a small succession affidavit. Can you whip one of those up for us? And then I ask 2 questions. Number 1, did your father have a will? And if they say yes, then I have to say small succession affidavit procedure not available. And then, but maybe they'll say, no, Dad didn't have a will. And then I ask question number 2, which is the same questions the banker should ask. Did everything that your dad owned exceed $125,000? Well, yeah, he had this bank account at the bank and it was worth $50,000. And he had some shares of stock over here. And yeah, he had his home, and his home's worth $150,000. So yeah, when you add everything up, it's worth more than $125,000. So under those circumstances, small succession affidavit procedure not available. So you bankers, when somebody comes to your bank and you want to try to please your customer, and there's an account that's frozen and it's worth less than $125,000, don't just immediately tell them to go get a small succession affidavit completed. Ask them 2 questions. Did the person have a will? And did they have more than $125,000 in gross assets when you add together this account and other things that they owned when they died? So they have to have died without a will and with less than $125,000 in gross assets. Then, if they pass that test, then you can tell them to call me or get the succession affidavit, done however, and they can go down that path. All right, so that'll clear up a lot of things. If just every banker could watch this video, a lot of people's lives would be made a lot easier. Okay. Now, when you do the succession affidavit, and I'm starting to see some forms on the internet, and various companies either they put the forms on the internet or they charge for the forms or whatever, but they're there. So I'm assuming a lot of people are attempting to do some of this stuff themselves. Yes, they've got to get signatures notarized. Some people still get us to do it, and so nonetheless, that's what's out there. All right, so I'm going to refer to the statute. I'm not going to go through all of the details that need to be in the affidavit. But, obviously it's the date of death, that the person died without a will, marital status, kids, all that stuff is in there. Here's one, and this is where the bankers are messing up by telling people to do a small succession affidavit when they don't qualify for it, because people who sign these affidavits are swearing under penalty of perjury that the information contained in the affidavit is true, correct, and complete to the best of their knowledge, information, and belief. So they're swearing that there's no will and that everything's worth less than $125,000, and they're swearing under penalty of perjury. So just be careful. I've never seen anybody go to jail for lying on a small succession affidavit procedure, but it just doesn't make any sense, to lie and and go through the trouble that you go through when you're signing an affidavit that's not correct. Okay, so there's that. And then once all of the affidavit is prepared, the heirs sign it, and yes, there is a mechanism. I was dealing earlier this week with a family who wanted to get a small succession affidavit done. One of the 4 kids was in prison, and signing was just really, really difficult. So, in that affidavit, there can be a statement that an heir not signing the affidavit either cannot be located after exercise of reasonable diligence or was given 10 days notice by U.S. mail of the affiant's intent to execute an affidavit for small succession and did not object. So normally all of the heirs sign the affidavit, but there's a mechanism in case one or more can't or won't sign the affidavit. And there's requirements on how many people must sign, spouse, and all of that. So all that's in the statute. All right, and then once the affidavit is complete, it's pretty simple. I mentioned, bypassing all of the court filings and the judge's office and the judge's, court orders and all of that, which are typical in a succession or probate proceeding, whatever you want to call it. So once the affidavit is signed and all of the people signing the affidavit, swear that the person didn't have a will, everything's worth less than $125,000, all the information's complete, then a multiple original of the affidavit is sufficient to take to the bank or the financial institution to get those funds. And then a multiple original of the affidavit is to be recorded in the conveyance records in the office of the clerk of court in the parish where any immovable property described in the affidavit is situated after at least 90 days have elapsed from the date of the deceased's death. So not supposed to be able to record that small succession affidavit until 90 days has passed after the person died. So when the small succession affidavit does apply, I'll be it makes things easier. This probate or succession isn't in every circumstance a pain in the rump, but in many cases it is, and it's expensive and it's time consuming and it's a hassle, and sometimes things go south because they take long and they're stressful, and family member just died, and now surviving family members are having to get together and work together and dividing up money, and there's the potential for difficulty. So the quicker and easier that estate settlement process is, the more likely it's going to go smooth. So the small succession affidavit procedure, kind of really common here in Louisiana, where a lot of people pass away without a will and without $125,000 in assets. And then there's a lot of people passing away out of state who own a piece of property or a partial interest in the piece of property in Louisiana, and that piece of property is not worth more than $125,000. So we use it when we can. Be aware that it exists. Make sure you follow the rules. If you don't qualify for the small succession affidavit, then don't use it. Don't swear under penalties of perjury that the person didn't have a will when they did, or they had a total of more than $125,000. Don't swear that they had less than $125,000 of assets when they had more than that. But again, if you need our law office's help, feel free to let us know. We handle that whole process for some folks when requested, and they want us to help them through it, because you do have to list the assets and comply with all of the terms of the statute. Sometimes that is difficult for people to really understand what they need to supply, and it can avoid title problems down the road when you go to sell a piece of property that you inherited through the small succession affidavit procedure. Okay, hope that helps. I'm Paul Rabelais. Make sure you hit the subscribe button and the notification bell so you don't miss anything. If you've subscribed already, thank you. That's awesome. And smash the thumbs up button would be great if you felt like this provided you with some value. And then stay tuned every morning, 10 a.m. Central Time, where I give you a new piece of estate planning or estate settlement or estate administration information that you probably can't get anywhere else, and can help you preserve and protect what you have for your family. We'll see you tomorrow.